by a tribunal of first instance, and subsequently the approach to proportionality, in particular for the protected characteristic of disability in respect of both Section 15 and Section 19 Equality Act 2010, but also in respect of age for the purposes of Section 19 Equality Act. Just before I get into this, can I please make sure that we have all the correct bundles? We've checked, but I just want to be double sure that the court should have a core bundle and a supplementary bundle and 2 authorities bundles.
Yes.
Thank you very much. By way of brief summary, the claimant is disabled by way of attention deficit hyperactivity disorder, ADHD, and a sleeping disorder, which together constitute the disability. They have a significant impact on his executive functioning. Disability was conceded by the respondent for the whole of the material period. The claimant rose to being a senior broadcast journalist before being employed by the respondent as a grade 6 assistant lecturer in journalism in the Respondent School of Media and Performing Arts. The claimant applied and or requested a promotion to the position of a grade 7 lecturer in journalism in the years 2017, 2018, 2019, and then up until 2020. Despite his experience, his skills, and his exemplary teaching record, all of his applications were rejected. He asserts that this is because he couldn't satisfy the requirements of the respondent's academic progression process, which we call the framework for shorthand. And in particular, he asserts that it was substantially more difficult for him to satisfy the criteria of that framework, which required him either to have a PhD or be on the pathway to having a PhD, and demonstrating research excellence. Together, we've referred to those in our skeleton argument as the PhD and the research criteria, due to the impairments in his executive functioning. My structure this morning in my submissions will be that I intend to take the court first to the legal framework of the Equality Act itself. Then I intend to take the court to some of the key factual findings by the Employment Tribunal, where appropriate, some of the EAT findings, and also, because I don't shy away from a perversity appeal in part, some of the initial documents that were before the tribunal in respect of the applications themselves. So a very limited number of those documents, which provide useful context to understanding both the tribunal's findings and our submissions. And then I will focus on the specifics of our grounds of appeal, and I will take ground 1, followed by ground 3, and then 2 and 4 together, both of which deal with proportionality. And I hope to be between 2.5 to 3 hours at the outset. I hope to finish by lunch, but if not, slightly over lunch. And my learned friend has indicated that he'll be about an hour. So turning first, please, to the scheme of the Equality Act, there are 4 separate provisions in the Act which provide for a form of disability discrimination. 2 of those, Section 13, direct discrimination, and Section 19, indirect discrimination, apply to the range of protected characteristics within the Equality Act, including disability. 2 of the provisions, Section 15 and Section 20, both deal only with disability discrimination. And those paragraphs recognise in particular that the scheme and purpose behind legislating for disability discrimination acknowledges as it must that disability discrimination may differ from other forms of discrimination, and that to achieve substantive equality for disabled people, additional provision is or may be required. And so we have Section 15 and Section 20. So if I could turn the court please to the authorities bundle, and it's at section A of the authorities bundle that we find first section 15 at page 12. And we see here that this is discrimination arising from disability. A person discriminates against a disabled person if A treats B unfavourably because of something arising in consequence of B's disability, and B, A cannot show that the treatment is a proportionate means of achieving a legitimate aim. Pausing there for a moment to emphasise the following points. 15.1a refers to unfavourable treatment. Unlike direct discrimination, which it's in the bundle but I needn't take you to it, section 13, that is a comparative test of less favourable treatment. Section 15 doesn't require any element of comparison. It simply requires unfavourable treatment. And part 2 of that equation is because of something arising in consequence of B's disability. That will form ground 1 of my appeal. And then the second part, A cannot show that the treatment is a proportionate means of achieving a legitimate aim. That's the justification aspect, and that forms ground 2 and ground 2 of our appeal. Then if I take you to the next section, which is at page 14. So I'm so sorry, before I move on, could I just also point out on section 15, the subsection 2, which is a knowledge criteria in respect of the disability itself. So subsection 1 doesn't apply if A didn't know or couldn't reasonably have been expected to know that B had the disability. For our purposes, the respondent conceded knowledge of the disability throughout. So it doesn't come into play. Section 19, at page 14, following on, is the indirect discrimination provisions. And these form our grounds 3 and 4. And we see there, subsection 1, a person discriminates against another if A applies to B a provision, criterion, or practice, the PCP, which is discriminatory in relation to a relevant protected characteristics, in our case, age and disability, of B's. Subsection 2, for the purposes of subsection 1, a PCP is discriminatory in relation to a relevant protected characteristic of B's if A applies or would apply it to persons with whom B does not share the characteristic. B, it puts or would put persons with whom B shares the characteristic at a particular disadvantage when compared with persons with whom B does not share it. Pausing there, that is what we will refer to and is commonly referred to as group disadvantage. And then C, it puts or would put B at that disadvantage. In other words, there must be then the individual disadvantage. And subsection D, A cannot show it to be a proportionate means of achieving a legitimate aim. So we see the same construction of proportionality justification, section 19D. There is no knowledge criteria in section 19. Then if I turn the court please to page 17, and we have here section 20, which is along with section 21, the duty on the respondent to make adjustments, so the third limb or the fourth limb of the Equality Act on disability. And the relevant section is at 20 subsection 3. The first requirement is a requirement where a PCP of A's puts a disabled person at a substantial disadvantage in relation to a relevant matter in comparison with persons who are not disabled, to take such steps as it is reasonable to have to take to avoid the disadvantage. So in shorthand, that is the duty to make reasonable adjustments. I needn't turn it up.
So that structure, in summary, reverts back to indirect discrimination as described in section 19.
I'm so sorry, my lady.
Well, the requirement applies, in effect, where there is indirect discrimination under section 19.
No.
No?
No. It uses the same language of PCP.
Oh, hang on, substantial, not particular disadvantage.
There is no requirement for indirect discrimination at all to have a Section 20 claim. It can be an entirely standalone claim. There are some similar concepts, that of a PCP, but substantial disadvantage and particular disadvantage may not be the same in every case. Yeah. And the PCP, in fact, may be different because they are aimed at different matters. Perhaps I can explain it like this. Indirect discrimination typically is based around a policy or a practice which is aimed at, which affects groups substantively. The duty on an employer to make a reasonable adjustment applies in respect of the individual.
So there may not be group disadvantage.
There may not be group disadvantage.
Okay,
they are not the same.
Okay, that's very helpful.
My lady, I suspect it's the term PCP particularly which has caused some distraction there, but they are used in a different concept.
Distracted. So thank you for explaining that to me.
I don't intend to turn it up, but simply for your reference, because Section 20 isn't directly an issue in this case. But paragraph 20, subsection 1b of Schedule 8 to the Equality Act, it's in the Authorities Bundle at tab A39, but I don't invite you to turn it up, does have a knowledge requirement for this provision to bite, but the knowledge requirement is in respect of the substantial disadvantage. So there is a requirement. Section 20 doesn't bite if the employer couldn't have been expected to know about the substantial disadvantage. And that demonstrates that there are structural differences and differences in the legal tests between each of these provisions. But as I say, Section 20 isn't directly an issue in this case. Turning then, if I may, to the factual matrix and background of the case. I'm going to turn to our skeleton for ease of reference. It's in the back of the bundle at page 365, but I think we've handed up, my Moylan has handed up some copies of our skeleton if it's easier for you to have it to hand rather than in the bundle. So dealing first with disability, I'm going to take court, for ease of reference, please, to paragraph 8 of my skeleton and onwards, which is at page 367. ADHD, at paragraph 9, is a lifelong condition for which the claimant was formally diagnosed by a Dr. Beskerby Chambers on the 10th of October 2018. I don't propose to take you to the tribunal's specific findings or the documentation on this, because I think this is agreed, and I hope that this is an agreed summary of the position. The respondent conceded, and the tribunal accepted, that the impact of his disability was as set out in the list of issues, and I will just take you to that document, please. It's the core bundle at page 228. At paragraph 11 in the middle of that page, the list of issues. This was appended to the back of the tribunal's judgment. And you see 11, if so, it is agreed that the following somethings arise in consequence of his disability. A, the relevant symptoms of his ADHD and or sleep disorder are inattentiveness and impaired concentration, difficulties with task completion, poor organisational prioritisation and planning skills, constant fatigue, impulsiveness and hyperactivity. You see at B, the difficulties in interviews, which it was agreed meant it was more difficult for the claimant to take advantage of the external route to promotion, and made it more favourable, the claimant says, necessary to go through the academic framework progression. And C, it was agreed that the claimant's resultant difficulty in focusing on and writing academic publications and the corresponding difficulty in demonstrating adequate achievement or experience in research and obtaining, it should say, a PhD flowed. Paragraph 10 of my skeleton, and for ease, I won't take you repeatedly back to the tribunal's findings, but the reference is there for you. Dr. Bescaby Chambers' report of the 22nd of October, paragraph 10 of my skeleton, observes throughout most of his life, organisation and planning has been a real problem. He can't organise himself to get started on projects. Paragraph 10 of our skeleton.
Yes.
He can't organise himself to get started on projects and tends to leave things till the last minute. He gets distractible and goes off in different directions. And then at paragraph 11, his letter to occupational health, I would like to take you to that letter so you have the full context of his disability in mind. It's in the supplementary bundle, please, at pages 92 to 94. And starting under, if you see the bullet point 1, attention deficit hyperactivity disorder, it records this disorder impacts on his life on a daily basis. There can be difficulties with concentration leading to distractibility, as well as difficulties with organisation and planning, which can affect task completion. Also, items can be easily be misplaced. And then, if you turn over the page, please. I won't read this out, but I would simply ask you to read the first 4 paragraphs of that. And then the penultimate paragraph on the page, the pressure placed on him by the suggestion of completing a PhD. And then over the page, the first paragraph.
Yes.
Thank you very much. And we see in paragraph 12 of our skeleton, we see that those views were then incorporated into an OH report of the 15th of August 2019. I won't trouble you to read those again. Paragraph 13, owing to those executive functioning impairments that we've looked at, on the 18th of September, Dr. Vescoby Chambers wrote to the claimant's GP stating that he was just not organised to be able to complete a PhD. And all of these are referred to in the tribunal's findings that I've set out in the skeleton. At paragraph 14 to 16 of our skeleton, we deal there with the impact of the sleep disorder. In short, it resulted in constant fatigue and it exacerbated the cognitive difficulties associated with ADHD. This was illustrated in a report by Dr. Zaiwala, who said that the severity of his sleep disturbance is likely to have an impact on his daytime functioning, with in particular difficulty in planning and organising and retaining information in addition to constant tiredness. And in view of the severity of his sleep disorder, he will find it very difficult at present to successfully work towards achieving a higher degree. And then finally in paragraph 2016 also there, further evidence from Dr. Pritchard, the claimant's GP, about his sleep disorder, which gives him a marked impact in difficulty functioning, can massively affect his concentration, and he can find it very difficult to organise himself at times. She continued, I understand he's currently in the process of studying for a PhD, and obviously his issues with sleep does impact on his ability to study for prolonged periods. So the medical evidence before the tribunal and in its own findings plainly shows that the claimant's disability, both the ADHD and the sleep disorder, individually and cumulatively created difficulties for the claimant's engagement with various aspects of academic study and research. And I then turn to the framework, the academic framework itself. And I set this out in paragraph 17 to 21 of our skeleton. The claimant was employed as a grade 6 assistant lecturer in journalism and media in 2013 in the Respondent School of Media and Performing Arts. By January 2018 and 2019, he'd started undertaking part-time work for the Respondent as a grade 7 hourly paid lecturer in addition to assistant lecturer duties. With effect from January 2017, and this is paragraph 18, the respondent created the framework, that's the academic framework for progression, for internal progression. And that framework had a 4-stage paper-based process. 1, a standard form application. 2, the consideration by the applicant's head of school. 3, if supported by the head of school, the application was then referred to a faculty panel. And 4, if supported by the faculty panel, referred to the respondent senior leadership team for final consideration. And underlying the framework, the tribunal found, was the respondent's objective expressed in its corporate strategy to increase the number of academic staff with doctorates by 30%. And again, I have the tribunal's references in there, but what I propose to take the court to relatively swiftly are some of the original documents so that you can see the application process and what was actually contained within it. So turning first, please, in the supplementary bundle to page 108. Covers the process that the claimant will have followed and that I've just summarised in short for you, but that's where it's set out. If you then turn, and I don't invite you to read it in any detail, but it's there for you. But I would like you then to turn to the application itself. So at at page 110, you have the form itself, and it sets out various criteria. So this is the form that the applicant will have filled out. And you see on that form, underneath progression from grade 6 to grade 7 academic role, the pro forma criteria and evidence. Applicants will be required to complete part 1 of the form below with recent evidence against each of the criteria, including appropriate evidence to support statements made. And then part 2 should be completed by the applicant's line manager, signed off by the relevant head of school, etc. And if you turn to part 1, at the bottom of that page, the academic progression process recognises a high level of achievement in 4 broad areas of activity: teaching and learning, research and scholarship, which is one of the ones that the claimant had difficulty with, enterprise and leadership and management. The promotions process requires evidence of a high level of contribution and attainment in the areas which are the current focus of your role, demonstrating excellence, etc. Over the page, you see the actual criteria for progression from 6 to 7. Demonstrating activity which illustrates ability to meet the requirements, successful completion of probationary period, and, third bullet point there, have attained a PhD or exceptionally demonstrate equivalence in contribution to professional practice. So the equivalence was an exceptional option, but the otherwise having attained a PhD is set out there. And then there are various aspects which need to be filled in, and I'll come back to those in a moment. If you scroll down, you see, I won't take you to any detail, 1, teaching, learning and assessment, 2, research and scholarship, 3, enterprise on page 114, and then 4 on page 113 is leadership and management. And then you see 5, case for progression. And then on page 114, you see part 2, which is to be completed by the line manager. And that's where you see to be completed by the line manager, and the line manager has the opportunity to comment. And then at the top of the next page, SB 115, it can be completed by the head of school. It simply says, please set out the business case for this promotion, including the specific business need, the opportunity for the applicant to operate at the next grade, the budget availability, and how it fits into your people plan. So that's where we see the words business case and business need on the application form itself and the progression criteria. But it becomes immediately obvious that whilst there is all the detail that we've seen on progression for a criteria, there is none other than what we see here for business case. So the business case is defined, if it's defined, in these very broad terms: business need, opportunity for the applicant to operate at the next grade, budget availability, and how it fits into the people plan. So there is a general set of concepts, I would say, rather than criteria. what those concepts do is suggest that there could be various factors, not just budget. In other words, business case isn't just budget. It could involve different aspects. And we suggest that when you read those words on their own, those aspects, those concepts, the concept of a business case could include the perceived strength of an individual application, including the extent to which the applicant meets the research and PhD criteria. We say that those words that you see on page 115 are broad enough to carry that connotation.
Sorry, so you're saying that business case, you say, should be construed as meaning or including the excellence of the candidate?
It could do. It could do.
Where do we get that from?
Well, I'm going to take you in a moment to what was actually written by a line manager and show you how it was understood. But what I say here is when you see on page 115, where it says, please set out the business case for the promotion, including specific business needs, opportunity for applicant to operate, budget availability, and how it fits in. That is a broad enough set of concepts to carry the connotation of the strength of the application. And I'll show you why I say that in a moment.
Well, this may be very important indeed. What do you say the reference to business needs means?
Well, I say that that itself could look at the strength of the research criteria or the strength of the application. And the reason why I say business need might consider that is because that's exactly what one of the line managers who looked at the claimant's application thought. Perhaps could I come back to this just when I take you to the actual application?
Well, I'd just like to know what you say and then what the ET found.
Yes.
Specific business need refers to.
Well, we say specific business need. The tribunal, first of all, made no findings on what specific business need or business case meant. So the tribunal uses business need and business case interchangeably throughout the judgment. And at one place that I will take you to in the course of the morning seems to equate the business case or business need only with budget. So what the tribunal doesn't do in any of its judgment is set out what business case encompasses or what business need is, if it's separate or the same. But it does seem to suggest in at least one place, one significant conclusion, that it is only a question of budget. And we say that when you look at not only this document, which contains a range of things, but actually the way that the line managers understood what business need and business case might have meant, it was wide enough to encompass. If they thought this applicant was good enough, they could create a business case or need for him.
Good enough for what?
Good enough for progression.
Yeah, simply promotion in the abstract, not to a specific post.
Well, what I will show you is that it looks as though, at the very least, if a line manager or head of school or line manager reviewing the business case thought, actually, this is a very strong application and we can create space for a grade 7 lecturer because he's so good that we need to have him. And that's why it will fit in our people plan. That is how business case could have been understood. We say it was wide enough to embrace that concept.
But if it includes the excellence of the applicant, what does it add to the other bits of the form? Well,
The applicant fills out the first bit, and this is what the line manager, the head of the school, fills out. So the short point is the tribunal don't make any findings about what business case or business need mean. We say that's important.
What findings were they asked to make?
Well,
This was an 8-day hearing with lots of evidence.
Yes.
And what were they asked to say?
Will I just turn?
Yes.
I'm told that the respondent raised the business case as a means of rebutting the disadvantage, the question on disadvantage.
Is this dealt with in the list of issues?
I don't think it is it? Oh, it is. 13A.
Yes.
In fact, it appears in more than one place, my lord. At 12,
Yes.
the respondent says that the claimant wasn't required to formulate the business case, was responsible to the head of school, but the respondent averred that the claimant wouldn't have been subjected to the acts because there was no business case for its progression.
Yes.
And then at 13, the claimant said there was a clear business case. And then at 13A, well, I don't think there was a specific issue setting out what exactly is the business case, but the concept of the business case was clearly an important aspect of the respondent's defence.
Yes.
And what we say is that in short, if I may, let me take you to the applications, because I think it will become obvious what I'm trying to say.
Yes.
So if I go first to the 2017 application, the claimant applied first for progression in February 2017, and I'm in paragraph 22 of my skeleton. The application was rejected by the head of school, Dr. Garrett Brown, and she provided reasons in an email of 27th of March 2017, which focused expressly on the PhD research criteria. At paragraph 44 of the tribunal's judgment, and perhaps I can just take you to this directly, it's at page 164 of the core bundle. Dr. Garrett Brown, paragraph 44 of the tribunal's judgment, identified where she viewed the application as deficient, and that was evidence of having completed or begun a PhD or demonstration of equivalency, evidence of trajectory towards peer-reviewed publications, a national profile and or income generation through association with research and or enterprise projects, and evidence of peer teaching observations and related module evaluations. So that is what the tribunal found were the reasons given for the rejection.
Well, the finding by the tribunal is that those were the aspects of the application which she considered to be deficient. It might not necessarily be quite the same thing.
Well, those are the reasons that were given to him.
Right.
There's no finding or reference in that email or any of the contemporaneous documents to the absence of a business case being an operative reason for the rejection of the claimant's application. Indeed, at paragraphs 36 to 37 of the judgment, the tribunal referred to other applicants in 2017 who did advance within the Faculty of Arts and Humanities.
Yes, but so what?
Well, the significance of that is that if the point is that there was no budget, then other people wouldn't have advanced. So if the business case only meant a budget, others within that faculty wouldn't advance. There was no budget for
Well, it
progression.
depends on what the budget was for. I mean, you could either have no budget at all, or you could have a budget which didn't include this post.
Well, but then one would have to be extremely clear about the findings, about what the budget was. But the point here is that if the business case meant, if the tribunal concludes no business case, if the tribunal says that means no budget, other people have advanced. I simply point that out at this stage, as I'm taking you through the findings.
The tribunal's finding was that there was no business case for progression, including in 2017.
Yes. And what I say is, well, but you have to look at its own findings. Some people did progress. Now, if the business case means the budget, then that finding doesn't work.
Well, then you could have put, Mr. Jackson could have put it to the respondent's witness that you're lying toe rags and that this was a sham. And very often it happens in discrimination cases that the employer says we haven't got the money, and it's put to the witnesses that the real reason is because you didn't like him, or you thought he wasn't qualified, or all sorts of other reasons, and the tribunal has to make findings, but it doesn't appear to have been run that way.
Well, I think perhaps what I'd like to do is perhaps I can just make some progress to show you the documents on the applications, and I will come back to the way in which this fits together, the budget and the business case, because it is an important point. But I will come back to it. And perhaps I could just do that. Thank you. What I then propose to take you to is the Employment Tribunal paragraph 61, 168. And we see that Dr. Hyde's then rejected the claimant's grievance appeal. So the claimant puts in an appeal against his rejection, and then Dr. Hyde's sends him a letter to explain. And his reasons that we see in paragraph 61 also focus on the academic and research requirements of the framework. I will just take you in particular to a few of the paragraphs, because it's quite a long document. But in paragraph 61, the second internal paragraph, although it was brief, the written feedback you received on your application under areas for development identified specific areas that required further development of your research profile. These were directly related to the research criteria for progression. So there's a straightforward link there with research. Then on the next page, 169, you see the first paragraph itself refers to research strategy and criteria for progression. And the next paragraph refers to referable chapters. And then you see in the middle of that page, during our meeting, we discussed the need for a head of school to create a business case for support. I won't elaborate on this here, but then it goes on to say, and I won't read this out, but I'll simply paraphrase it, that the university was seeking to increase the number of staff with doctorates by 30%, so therefore its corporate strategy, to increase the number of doctorate completions, which gave a strong message to staff about the university trajectory. In other words, he was highlighting in this letter to the applicant that doctorates remained important. He said, by adding in a progression framework which gives staff at assistant lecturer level the opportunity to apply for progression, this was a positive way forward. So there was a statement of intent about the inclusion of doctorates. And then he sets out, at the bottom of that page, the criteria that we've looked at again, focusing on PhD and including research and scholarship, and says over the page, it's clear from these criteria that the expectation to achieve a PhD is also made explicit in the documentation supporting the progression process, whilst there's no absolute requirement for all staff to have obtained a PhD in order to successfully progress. It is the norm. So again, it is being emphasised to the claimant in the rejection of his grievance that it was the norm to have a PhD. And then had he wished to pursue a PhD, be that via the traditional route or publication route, you could have discussed it with your school management team in order to understand what options may be available. During my investigations, I found no evidence to highlight that you sought guidance or support for undertaking a PhD, etc. But the relevance of having the PhD and the research criteria is underscored in Dr. Hyde's own letter. So we say that those explanations, those reasons given in 2017 by the individuals themselves, the head of school and Dr. Hyde, Dr. Garrett Brown and Dr. Hyde themselves, demonstrate that they were linked to the research criteria and the PhD. 2018, the 2018 application, I deal with paragraph 27 and 28 of our skeleton. By this time, the claimant had secured a PhD supervisor and was undertaking grade 7 work. Now, again, we say that the application by Dr. Hyde's directly refers the research and PhD criteria. And here, I'd like to take you just to the original documents. In the supplementary bundle at page 54, you see the line manager. So I've skipped past the claimant's own application, but this is at the end of that form. You see there to be completed by the line manager. This was Mr. Dawkins. This is a supportive comment in his favour. And you see that he himself refers to the relevance of the PhD. So it's in the substantive second paragraph, 5 or 6 lines down. Although he does not possess a PhD, his ongoing research activities are developing and significant, and with the necessary support, could form the basis for a PhD. So we see that that is referred to directly as a cause for improvement of the application by and support by his line manager. And then over the page...
I should know, but I don't. What's MEQ?
On the... Oh, I'm sorry. I think it's Module Evaluation Questionnaire. Thank you. Thank you very much. And then at page 55 of the supplementary bundle, that application goes on to be completed by Dr. Garrett Brown, who was the head of the school. And this is the form that I took you to in pro forma before. amply set out the business case for the promotion, including the specific business need, opportunity, etc. And we see what Dr. Garrett-Brown says. Since his last progression application, Simon has been working with his research mentor to develop a pathway towards PhD study through a consolidation of his existing practice and research. His work has demonstrated his ability to operate at L level, etc., supported the new course rollout, and assumed ownership of module leadership, and then as an existing 0.6 AL member of staff, he's supporting teaching. In addition to the increase in salary scale, there would potentially be additional hours required at AL level to backfill the teaching and learning support activities. So on the face of it, that is the head of school's business case for the promotion in support of the applicant there. And we see the very first line of that refers to his working with his research mentor on the PhD. So that, in short point, is the point I was making before, my lord, which is that the business case, as recognised in reality by the head of school, seems there to be filling out the substantive strength of the application.
But an unkind person might say, this is a candidate who simply hasn't read the exam question and has answered a different question from the question that the exam asked.
Well, I struggle to help you with that, but that is the evidence that was before the tribunal. That is the evidence on what she understood, Dr. Garrett-Brown, the head of school, understood to be the business case. And we see that on what she has filled in, she herself has referred to the PhD criteria, and it looks as though she's referring to the strength of the application.
Yes. Including the specific business need, the opportunity to operate the next grade, the budget availability, and how it fits into your plan. And then in the final, who's the academic dean of faculty, who signs off on the last page.
And what you see that he does is talk about, again, the strength of the application, significant progress, clear demonstration of areas of excellence in teaching and learning, etc.
But in the end, says budget availability, no. Who is it? You gave it. Dr. Garrett-Brown is the head of school. Who's the
academic dean is
of faculty?
Dr. Hydes. Yeah, Dr. Hydes.
Hydes.
But what we see in the comments there, so we do see no recommendation to proceed and no budget availability, but there's no explanation of that. The comments effectively say some good progress, he's doing better, he understands it better, but the activities and outputs listed do not yet form the basis of a coherent research direction. So if you put that and can't as yet constitute research activity at the expected level. So if you put that together, you have a supportive head of school saying the business case is effectively the strength of this application. This is someone who does understand the research and PhD criteria. Then you have the academic dean, Dr. Hydes, saying this is a better application than last year, but it's still not there on the research criteria. And so is there a recommendation to proceed? What we see, no. Confirmation of budget availability, no. But we can't know, we don't know, whether how the strength of the application goes to the budget availability. In other words, the business case isn't necessarily the same as the budget. I think that's the only point I need to make for now, is just to show you how that's been understood and how it's been recorded. I think that's all I need to do on that.
Did Dr. Hydes give evidence about this? Was he asked about it?
He did, and my learned junior has said that it was put to him that the business case was utterly unclear and couldn't displace the written disability-related reasons, and it was put to him that the PhD research deficiencies were the reasons repeatedly. That was put to him repeatedly.
And again,
Dr. Eric Brown wasn't called.
The finding of the tribunal was that there was no business case for progression in 2018 as well.
Yes. And yes.
May I interrupt, Mr. Dolly, just ask you a question about paragraph 225 of the ET's decision, which is on page 210 of the call bundle. In that paragraph,
Yes.
the ET refers to pages in the bundle in support of its finding that there was no business case for progression in any of the relevant years.
Sorry, are you on 225? Did you
Yes,
say that?
paragraph 225
Yes.
of the ET's decision.
Yeah.
Thus, in each year that there was thus no business case for progression, and then they refer to pages of presumably the ET bundle in support of that finding.
I think there's a paragraph.
I think
in
they're
their decision.
paragraphs.
Oh, I see, paragraphs.
It's referring back
the
to
early
earlier
decision.
paragraphs.
Sorry, my fault. Yes, I'm being stupid.
In the decision. And 114 addresses the very form we're looking at and the response to confirmation of budget availability being in the negative.
Yes.
114 and 5.
It sets out at 113 the exactly what I've just read to you.
Yes.
114, and then so that it simply refers to that. So that's what I've taken you to, but I thought it was helpful to see the
Yes.
original document and how it was set out. Again, for your reference, and I simply make this point for your reference at this stage. The tribunal also sets out paragraphs 119 that year 8 of the 11 applications for progression across the university were rejected at faculty level, and the individuals referred to final consideration progressed. There was no evidence presented or findings made that there was no available budget for promotions in 2018. So we have what we've seen and nothing else. Then in 2019, the claimant made his third application for progression. And I deal with this in our skeleton at paragraph 31. And this application, you see it also in the tribunal's findings at deals with it from 135 onwards.
There's 133 onwards.
I think that's dealing with it deals with various things that happened pre the actual application. I think various emails. Yeah, there was various emails in the run up to the application, but the actual application, the tribunal deals with it 135, 136. And this time, the applicant had outlined the impacts of his ADHD on his ability to undertake research activity and pursue a PhD. Then Dr. Garrett Brown, if you recall, the head of school, the application didn't proceed. She rejected it at the head of school at the head of school level, and although she says that there is no business case, she also says that the application is not supported because of the claimant's failure to meet the PhD research criteria. And so if you look at the paragraph 136, it records her reasons in italics. At this point, however, the application cannot be supported as Simon's research profile is not yet in line with the academic role descriptor for grade 7, nor is there evidence of a clear pathway to PhD or equivalency underway. So her own reasons there set out at least why the application can't be supported in respect of the research and PhD. And then she goes on to say that from a business case perspective, we can't, we're not currently able to support a growth or extension of level in the staff base with journalism due to falling application numbers.
It's a very striking fall, isn't it? In 1 year, from 196 applications to 119.
Yes. In fact, this is the only year in which all of the applications, there were 3, for progression from grade 6 to grade 7 within the Faculty of Arts and Humanities were rejected at the head of school stage. That was the only year in which that in fact happened. I needn't trouble you with the 2020 request. The EAT has remitted the 2020 related request back for redetermination, so I'll just tell you that it's there, but I don't need to go to it. With those factual backgrounds in mind, I turn then, please, to my first ground of appeal. That is that the ET, and subsequently the EAT, misapplied the threshold causation test and therefore failed to apply the correct legal test pursuant to section 15(1)(a) Equality Act, and or failed to attach the appropriate weight to its own factual findings and the evidence, and or was perverse when concluding that the availability of additional reasons meant that the unfavourable treatment was not because of something arising in consequence of the claimant's disability. So I start taking the tribunal, please, back to our skeleton.
Yes.
And I start the exposition of the law at paragraph 37 on page 375 of the core bundle, if you're using that. So section 15, we're looking at section 15(1)(a). A treats B unfavourably because of something arising in consequence of B's disability. Where unfavourable treatment is established, and of course unfavourable treatment was conceded, so in each of the years 2017, 2018, 2019, the rejection was conceded to be unfavourable treatment by the respondent. So where unfavourable treatment is established, 2 questions of causation arise. 1, did A treat B unfavourably because of an identified something? And 2, did that something arise in consequence of the complainant's disability? The first question involves an examination of the putative discriminator's mind as to what the reasons for the unfavourable treatment were. It is satisfied if the identified something was more than a trivial part of the reason for unfavourable treatment. So I'd like to take you to 2 authorities, please, to make good those points. First of all, in the authorities bundle, if I could turn you to City of York Council and Grosset, which is at tab 20, or is the court working from electronic bundles or physical
Speaking
bundles?
for myself, no.
Tab 20, please.
Yes.
The Grosset. Oh, sorry. It's tab 30. I'm afraid my tabbing I'm afraid my tabbing isn't correct.
Don't
so
worry,
I'm going to
we'll find it.
turn back.
It's a chronological bundle anyway.
30.
So,
Tab
yes,
30.
it is indeed tab 30.
So this was a Court of Appeal authority. This case concerned a secondary school teacher who had cystic fibrosis, and his disability required him to undertake a punishing and tiring exercise regime. What happened was that he'd showed some 15 and 16-year-olds an 18 rated horror film without approval from the school or parents, and subsequently he was dismissed for gross misconduct. And the relevant parts of the claim on section, he brought proceedings under section 15. And if I turn you, please, first to paragraphs 36, which is, I think I'd better just check that my electronic bundle syncs up with your physical. It's page 405 of my electronic bundle.
Paragraph 36, on
Paragraph
its proper
36.
construction, etc.
Thank you very much. On its proper construction, section 15 requires an investigation of two distinct causative issues. Did A treat B unfavourably because of an identified something, and two, did that something arise in consequence of disability? And I just invite the court to read 37 and 38, please. And then if I could turn the court, while we have the authority open in front of us, to paragraph 44, which is at page 407. There was a discussion by members of the court about the role of the explanatory notes. And for present purposes, I think what really matters is the explanation rather than the significance of the explanatory notes. And you can see the explanatory notes to section 15 set out within paragraph 44 there. Internal paragraph 70 on the explanatory notes, background. Section is a new provision. The DDA provided protection from disability-related discrimination, but following Malcolm, those provisions no longer provide the degree of protection from disability-related discrimination that's intended for disabled people. This section is aimed at re-establishing an appropriate balance between enabling a disabled person to make a case of experiencing a detriment which arises because of his or her disability, and providing an opportunity for an employer or other person to defend the treatment. And then at paragraph 45, the explanatory notes indicate that Parliament intended section 15 to strike a new balance of interest between a claimant and a defendant in a discrimination case, where the alleged discrimination is not directly by reference to the claimant's disability, but arises from detrimental treatment by reference to something else which arises from the claimant's disability. And then moving forward to paragraph 47, Lord Justice Sale says it's clear that, as stated in the explanatory note, section 15 establishes a particular balance between a person suffering from a disability and a defendant. The risk of unfavourable treatment because of something that has arisen from the disability is cast onto the defendant rather than the claimant. If the defendant doesn't know that the claimant suffers from a disability, he has a defence. But if he does know that there's a disability, he'd be wise to look into the matter more carefully before taking unfavourable action. Defendant will also have a defence if he's able to justify the unfavourable treatment. It's worth bearing that in mind as to the purposive effect of the intention and effect of the section. Then, if I could turn the court to the next authority, which I think must be 31, tab 31, Sheikh Islami and University of Edinburgh. This was Mrs. Justice Simler, president of the EAT, as she then was, dealing with a case about a professor within the university's engineering department who had had twin sex and disability discrimination complaints. And she had claimed that her dismissal had been asserted on the basis of a work permit expiry, and that was simply to avoid the problem of her continued and sustained complaints of sex and disability discrimination. And so the EAT dealt with both the Section 20 complaint on appeal and, for our purposes, the Section 15 complaint, in which she asserted that her dismissal and various procedures relating to a failure to renew her work permit amounted to unfavourable treatment within the meaning of Section 15. And the relevant paragraph is 62 of Sheikh Islami, which is page 422. And it again sets out the Grosset test that we've just looked at. And it explains slightly further, if the something was more than a trivial part of the reason for unfavourable treatment, then stage 1 is satisfied. The second issue is a question of objective fact in light of the evidence. Then I'd like to turn to the case of Knizer, which was also, Mr. Justice, similar she then was. And that, I think, will be tab 26. And it's page 332, the case of Knizer and NHS England. And this was a case about a disabled applicant for a position within the NHS, and she claimed that the withdrawal of a job offer by the NHS and the provision of a negative reference by her former council employer amounted to Section 15 disability discrimination. And what the EAT does in that case is sets out at paragraph 31, in particular, a helpful exposition of the authorities to date. And you see that at page 336. And for present purposes, I'd invite you to read the whole of that paragraph in due course, but for present purposes, I'm going to take the court to specifically B and D. B, the tribunal must determine what caused the impugned treatment.
Can you just pause for a moment?
Yes, of course.
I don't know the facts of this case. I'd just like to look at the opening paragraph.
Thank you, Moylan.
31.
Sorry. Yes, paragraph 31 at page 336. And I specifically would like to invite the court to look at paragraphs B to D. I just invite you to read those
Yes.
now. And
There's a question of fact, as said at the bottom of D, to be robustly assessed whether something can be said properly arise in consequence of disability.
well, that's the second part of the question. Did that something arise in consequence of the complainant's disability? Is an objective question of fact. But I also wanted specifically to highlight in B the line that said, just as there may be more than one reason or cause for impugned treatment in a direct discrimination context, so too there may be more than one reason in a Section 15 context. Something that causes the unfavourable treatment need not be the main or the sole reason, must at least have a significant or more than trivial influence. And then in D, I also wanted to highlight there that the expression arising in consequence of could describe a range of causal links. So in other words, there's no requirement just to look at one. There could be multiple reasons, and as long as those are material in the sense of being more than trivial, then that would be sufficient, even if that involves a chain of links for Section 15.1a. And that, of course, reflects the low causative threshold, if you like, that was explained by Lord Justice Sales in Grosset.
But it's still got to amount to an effective reason for or cause of.
Still, well, it has to be, yes, it must be effective, but in the sense of being more than trivial. It doesn't have to be the only reason.
Well, let me give you a hypothetical. Suppose the appellant or anybody else at Coventry applies for, say, promotion to be Deputy Vice-Chancellor. I don't know how many Coventry has, but let's suppose it's 3. And he says, I want to be promoted to be Deputy Vice-Chancellor. And the reply, boiled down to its essentials, were, dear sir, we reject your application because A, there are no vacancies, and B, we don't think you're qualified. Do you say he wins his case for disability discrimination because even though there's no vacancy, they included the reason that you're not qualified?
Well, if that was a reason that they considered, the answer on the Grosset-Pneiser analysis, if it was a reason that was part of their reason, then the answer at stage 1 of Section 15.1a is yes.
So the only way they can avoid liability for potentially compensation for loss of a deputy vice-chancellor's salary is by saying, dear sir, there are no vacancies and therefore we will not consider the merits of your application.
Well, no, that's not what I say, and it's difficult with the hypothetical because it might depend on a range of things. But
yes.
So if it played any role at all in their decision making that he wasn't qualified, then if it played no role at all whatsoever, then probably the answer would be sorry. Yeah. The difficulty with the hypothetical is that if it played absolutely no role whatsoever, thinking about the triviality threshold, then the answer would be that Section 15 is not engaged. But so long as the triviality threshold is engaged at some level, so it was part of their reasoning. For example, had this been someone who they just thought was so brilliant we can't let him up, maybe we can create a role or push him into a role that starts later or something like that, then it might have been. As long as the triviality threshold, if it was just an ad script, there's no vacancy, that's the whole reason, but just so that you know in any event you're not qualified, then perhaps in those circumstances the answer would be no. But if it formed a part of the reason...
This is absolutely critical, as it seems to me.
Well,
this is the central point in the case.
Well, but my lord, the difficulty with the hypothetical in this is that we don't know whether, in your hypothetical, there may have been factors. If the answer was straightforwardly no vacancy, nothing at all, no way of getting there, then that probably wouldn't have engaged the triviality threshold. But if the reasoning was that it was in some way relevant, we might have had a vacancy if we'd had the best candidate, for example, and the reason why you weren't the best candidate was in some way arose in some consequence of your disability, then the triviality threshold would be engaged. And the relevance of the no vacancy or the assertion of no vacancy kicks in at proportionality or at remedy. So long as there is at the triviality threshold is engaged, it forms some part of their reason, even if not the only reason, then section 15.1a is engaged. And the relevance of the fact that actually in this year we couldn't create a vacancy or we weren't willing to consider a vacancy for whatever reason is something to be considered at the proportionality stage or at the remedy stage. If the answer was straightforwardly no, there's no vacancies, I don't know why you're applying, no one asked you to, there's no application process, etc., and you're not qualified anyway, it was just a kind of an add-on, then that's a factual finding, potentially. But it's difficult to deal with a hypothetical because a hypothetical might involve a range of circumstances. In short, what we say in our case is that when you look at the reasons given in this case, even if, never mind what the business case constituted or didn't constitute, even if the business case constituted a part of the reasons, it is clear on the tribunal's own findings and on the evidence that I've taken you to, that the applicant's disability, in other words, the fact that he found it harder to comply with the research and the PhD criteria, was part of the reason that they gave. It was part of the reason that were given to him for not progressing.
But might there not be a distinction between what he was told and what the factual position was? Because it doesn't matter what he was told if the reality is that there was no post. There's no post and there's no post, and that's the beginning and the end of it.
But there would have to be... But the tribunal's findings, the difficulty with that here is that the tribunal's findings actually were that those were the reasons he were given. That those were the reasons he was given. And we say, in the absence of the tribunal finding that those reasons, we say that the reasons that they have given clearly engage the threshold.
But so the submission seems to amount to a submission that if an employer does the courtesy of treating an application such as this on its merits and considering it on its merits, and gives reasons why the application fails on its merits, even if there isn't a post to appoint the person to, the employer is called.
Well, it isn't quite as straightforward as that. It isn't quite as straightforward as that, because what we say is section 15.1a is a low causative threshold. And if the employer's reasons include, never mind if they're only, but they include reasons which engage his disability. And we say when you look at each of these years, at least part of the reasons given included his disability, then section 15.1a was engaged. That's a low threshold. Whether or not a business case was about budget or the availability of any post is, we say, a question for the second stage. But at the moment, one has to keep one's eyes focused on what section 15.1a asks. The section 15.1a question is, did he treat him unfavourably because of an identified something? It doesn't have to be the only reason. It could be part of the reason, as long as it engaged the triviality threshold.
But doesn't that then, Ms. Jolly, can create a perverse incentive for an employer simply not to engage with the merits of an application and simply to say, sorry, we haven't got a post?
Well, if they haven't got a post and they say they haven't got a post, then that's the answer. But if they do engage with the merits of the application and they do say...
Sorry, can I just get a note? So, if they haven't got a post...
No, But I'm sorry, I just want to be clear about what you're saying. If they haven't got a post and they say there's no point applying, there's nothing there to apply to, that's something different. But in this circumstance of this case, and I'm going to take you to it, what you have is a process that is being supported at different stages, and it's advancing at different stages, and the reasons given are reasons that engage his disability. We say that unless you say that those reasons were completely meritless, those reasons were expressed to be beside the point, then the Section 51A threshold must be engaged, because these are the reasons given to the claimant when he, for example, raises a grievance in 2017 and says, why was my application rejected? The reasons I took you to in Dr. Hyde's letter, the reasons he was given. So unless the tribunal then makes a finding, additionally to say we didn't accept those reasons by Dr. Hyde, we don't accept those reasons by Dr. Hyde, we don't accept Dr. Garrett Brown's reasons in her business case, then Section 51A must be engaged.
So your submission is that it's an effective reason or cause of the unfavourable treatment, even though the unfavourable treatment would have happened in any event because of another reason, namely in this case, the lack of a business need.
Or may have happened in any event.
But you say it's still an effective
Yes.
cause. How is it an effective cause if it would have happened anyway because of another reason?
Well, because it's still part of their reasoning. It still
understand it, but it's got
forms
to be
part
effective.
of their reasoning.
It can be part of their reasoning, but not for the purposes of the statute as interpreted in these cases, an effective cause, because there is another reason, which means it would have happened anyway.
Well, the point is when you look. I think what the question is it an effective cause?
Well,
Does the tribunal look at the
yes.
links?
But if you look at what Lord Justice said there has to be a causal link. So and they just is similar effective cause and arising consequence of. So you're looking at, in sort of general terms, causation.
Yes.
And the point I'm seeing for myself, I'm struggling with, is that if there's another reason which would have had the same effect, i.e., would have by itself caused the unfavourable treatment, how this additional factor can still be said to be causative.
Well, I think perhaps the clue is in the way, my lord, that you expressed that. If it would have had that effect, is a different question. We say if something else, if for example, if part of the reason why they didn't, if part of the reason why they rejected his application was because he didn't comply with the research or the PhD criteria, if part of that reason, even if not the whole of that reason, then Section 51A is engaged. If another part of that reason is that there was no budget or there was no proper business case, whatever that means, then the right place to look at that is at the next stage on proportionality.
I mean, I can see if they're cumulative, that the statute doesn't require you to start segmenting them and saying, well, this was less than 40% or whatever. You don't need to do that. But the tribunal, the Employment Tribunal in 225, specifically looked at and said, well, this wasn't causative because there was no business need, or no business case, is how they put it. Well, they said no business case, no business need.
Yes.
As you said, they used them interchangeably. Anyway,
Well,
so you're I think I speak for myself again. I understand your submission.
yes, my submission is that, in a sense, my submission is that if you look at what they say at paragraphs 259 and 60, perhaps we should go there. So paragraph 259 of the tribunal's judgment is at page 209. Sorry, not 209.
217.
217.
Paragraphs 259 and 6.
Paragraphs 259 and... So just to be very clear, I just want to take you to the structure of where this appears. So section 15 starts at page 215, bottom of page 215. So this is the section dealing with discrimination arising from something, section 15. And it sets out at 253 the different rejections that were unfavourable treatment. And then you turn to page 259 for the reasons for why section 15 was rejected. And what's said here is in relation to Mr. Pipe's progression application, for the reasons we give at 224, and I'll take you back to it, and my lord, that's what you were referring to a moment ago. I think he means 225 there. There was no business case for a role in any of those. Even if he'd met the progression criteria, his applications would have necessarily failed because there was no role for him. The failure of his progression applications were thus in no sense whatsoever caused by the something arising from his disability. So in that sentence, the tribunal is saying they were in no sense whatsoever caused. So that is the question, my lord, that you were asking. But because of the absence of an available role or business case. But we say that the reasons given by the school themselves and the documents that I've taken you to demonstrated that a substantial cause in the sense of being more than trivial was his failure to satisfy those criteria. They were connected to something that arose in consequence of his disability, even if there were other reasons which also contributed to the rejection.
But you're in effect submitting that reason equals cause.
Well, because what we say is that those were the reasons given.
If it's given as a reason and it's other than a insignificant or trivial, it's causative.
We do.
For the purposes of the test as analysed.
We do. Cases. We do. And I just want to take you back, my lord, to paragraph, the reference to 224, just so you understand that more fully. It's at page 209. And what you see, just to be clear about what the tribunal is looking at in, I think he means 225, but at the top of that page is disadvantage. So this was dealing with the question of disadvantage for the purposes of the reasonable the reasonable adjustments claim. And there are a series of findings about reasonable adjustments. And the disadvantages in that context. But if you look at what is said in 225, which is I think what is meant, there was in each year there was no business case for progression. And given that formed an essential requirement, the absence of a business case for a role for Mr. Pipe meant neither he nor the group of which he were formed were put to a disadvantage. So the test that the tribunal is looking at is different because they're looking at the question of disadvantage for the purposes of Section 20. They're not looking at business case. They refer back to that. They're not looking at business case from an analysis of the Grosset Sheikh Islami perspective, which is, do the reasons given in any way materially suggest that his disability was at play? And we point
depends
also,
what you mean by in play or at play.
But what we say is that they needed to properly explore that, and they don't.
Can we go back? The 225 refers back to earlier paragraphs. Can we look at the 2019 application, which they deal with at 133 to 136. And at 133, they refer to an exchange of emails between Mr. Pipe and Dr. Clark, in which Mr. Pipe explained he'd secured an extension of time, but acknowledged it was unlikely a business case could be made because of falling student numbers. And then we go to 136.
Yes.
And this quotes from Dr. Garrett Brown's determination on the 2019 application, and she says, you referred us to the first paragraph about research profile is not yet in line, and then the second paragraph, which you cited to us, from a business case perspective, we are unfortunately not currently able to support a growth or extension level in the staff base with journalism due to falling application.
Yes.
Now, and you told us, I'm sure you're right, that all three applications for progression in the humanities faculty were rejected.
Yes.
Now, what finding do you say the tribunal should have made in relation to the 2019 application?
Well, I think there are 3 points that I would like to make about that. The first is that 2019 is we say the high point of the high point of the evidence on the business case. This is the only year in which the reference to the business case in this way appears in the reasons at all. That being the case, if the reasons given by Dr. Garrett Brown in 2019 are reasons that the tribunal can rely on in 2019, then they so ought to be reasons that the tribunal, if the tribunal looks at those reasons and takes them in 2019, the tribunal should equally look at those reasons in 2017 and 2018.
Well, in paragraph 47, they make a specific finding about 2017. They say there was a grievance investigation, a note of a meeting between Professor Foster and Mr. Dawkins recorded that Mr. Dawkins discussed the 2017 progression application with Mr. Pipe before it was lodged and had told Mr. Pipe there was no business case for a role for him. And then you go down to 49. Where Mr. Pipe's evidence was of us and Mr. Dawkins, we prefer the evidence of Mr. Dawkins, and specifically that he had explained the process to Mr. Pipe, what it entailed, and that a strong business case was needed, and Mr. Pipe had not provided one. So he was told, there's a finding there, that he was told in 2017 that he needed a strong business case, and he hadn't provided one.
Yes, but then he does apply, and the reasons given by Dr. Hyde that I took the court to in his appeal are reasons that relate to his, I think, two points, my lady.
Yeah.
First of all, the reasons given by Dr. Hyde, who was the person who did the rejection, are reasons that I took you to which concern the PhD and research. Right. So at the very least, those reasons are included in the person doing the rejecting in 2017's analysis.
Right.
In 2018, I've also taken you to both Dr. Garrett Brown and Dr. Hyde, and both of those sets of reasons also contain reasons relating to, or the connection being with research and PhD criteria.
Right.
And just going then back to, and then I will come back to what I say the business case, the findings on the business case mean in just a moment.
Right.
But on 2019, what we say is that if that was the high point of the business case, bearing in mind Dr. Garrett Brown's own reasons, those reasons still contained a reason in paragraph 136. They still contained a reason there relating to the research criterion. So we say that the fact that it was engaged, that she thought that that was an important point in that, means that section 15.1a does bite. But I accept that that is the high point of the conclusions on the business case.
All right. Well, don't leave it. You, when I asked you this question, you said you had 3 points. Number one was that this is the high point of the business case argument for the respondents, and then we started asking you other questions, and we never found out what your second and third points were.
My second point is that if I think my lady Lord Justice Laing said earlier, well, these are just reasons. They don't have to. Are the reasons given different from the cause? And I say, well, if the tribunal was entitled to look at Dr. Garrett Brown's reasons in 2019, they were equally required to look at the reasons in 2017 and 18 by those decision makers. And then the third point is about the business case itself. And I wanted to make a series of points about the business case that I deal with in paragraph 60 onwards of our skeleton. And so, just to be clear, we say that the analysis, the legal analysis from section 15.1a that we've looked at, we say it gets at home, and the court doesn't need to consider the detail of the arguments on the business case in section 15.1a. We say the correct place for that analysis is at the second stage of the test, at proportionality or remedy. But we will deal with the business case here because of the tribunal's own findings in 261, and also because of the manner in which the respondent considers the business case. So what we say is that, first of all, we say that the tribunal's findings in each year suggest that firstly, the concept of the business case was broader than budgetary constraints and overlapped with the strength of an application. Or secondly, if the business case was no more than a proxy for budget availability, its conclusions in 2017, and to a lesser extent, but nevertheless still in 2018, cannot be supported by its own findings of fact. And in a way, that's my point about the high point of 2019. And what we say is that the framework itself contained the key four-stage paper-based process against which achievements and standards would be measured. Even on the ET's own findings, we say the business case for progression was in addition to the applicants demonstrating the required achievements and standards. And we say that suggests that the business case was an adjunct requirement, but the primary assessment took place on the achievements and standards. And I take you first, please, to paragraph 222 of the tribunal's findings at page 209. And again, this is the section dealing with disadvantage. And the tribunal finds the fundamental requirements of the framework were embodied in two questions. Was there a recommendation to proceed, i.e. had the applicant met required standards, and was there a budget, i.e. business need for a role. So to the extent that the business case, what the tribunal seems to do there is equate budget and business need. But as I suggested to you earlier, the documents demonstrate that business need or business case is wider. The tribunal's, what we say is that the tribunal's own findings, that there's no budget in each year, if it's simply about budget, and therefore no possibility that the claimant could be promoted in each year, are belied, we say, by its findings in 2017, where multiple other applicants were promoted, if it's about budget, and in 2018 that 2 candidates, Lisa Perry and Una Murphy, were promoted outside the framework. And as the ET findings show, so the progression from grade 6 to grade 7 in that school happened. In fact, and just for your reference, it's paragraph 122 of the tribunal findings, Lisa Perry, who was the claimant's job share in grade 6, was promoted within the journalism course, albeit through an external approach, an external application, but she was the claimant's job share and she was promoted within journalism to grade 7.
I'm so sorry, can I interrupt? Does that mean then that the post to which she was promoted was advertised externally, so that anyone in and outside the university could apply to it?
Yes.
That's what you mean?
Yes.
So that's rather different from an internal promotion process, isn't it?
Well, the processes might be different, but to the extent that if the tribunal says business case equals budget, that if what the tribunal is saying is there was no budget for a grade 7 lecturer in 2018, we know that can't be right, because the claimant's own job share at grade 6 applied successfully, albeit through an external route, through the external advertisement, for a grade 7 position. So there plainly was a budget available for a grade 7 lecturer in 2018. The claimant's grade 6 job share got it.
Yes, but it was a post that, for whatever reason, had to be advertised externally. So if the claimant had wanted to be appointed to it, he would also have had to apply externally.
Yes, but well, perhaps that's right, but there's also an acknowledgement, an agreement, a concession by the respondent that the external route was harder for the claimant. So,
Sorry,
but focusing on the...
I'm lost here. The claimant didn't go in for the post for which Ms. Murphy or Ms. Perry was successful.
He applied for the grade 7 post.
Yes.
But he applied using the internal route,
Yes.
which was easier for him. Ms. Perry applied through the external advertisement, but got the grade 7 lecturer post within journalism.
But he didn't apply for the grade 7 post. He applied to be promoted to grade 7, but there wasn't a post for him to be promoted to,
Well,
as I understand it.
but that is the important point, my lady. If the tribunal says there's no budget for a grade 7, if that's what the tribunal means by business case, it's simply budget.
But they mean budget for an extra grade 7 post. I'm assuming, because it was externally advertised, that his job share was applying for an existing grade 7 post, which had to be advertised externally.
Well, but what we saw from the tribunal's reasons and the reasons that the tribunal found was that the significance of this, without trying to create too many links, is that if the tribunal is saying the budget is the only reason why he wasn't promoted to grade 7, there was no budget, we say they had to ask that question harder, because apparently there was a budget.
Well, they find there was no business case.
Yes. But the problem is that in 222, they say, was there a budget, i.e. a business need for a role?
Yes.
So the problem is that the tribunal interchanges business need, business case, and budget without any explanation. So we don't know what they mean by any of them. And the closest we get to understanding what they mean by business case or business need is what's at 222.2.
Yes.
Was there a budget for the role? But of course, when you look at the documents I took you to earlier, there was the business case was described differently. Here, budget or business need for the role seems to ignore what the definition of the business case was in the documents that the tribunal actually had in front of it, and says it was just about budget. And we say if it was just about budget, and only about budget, the evidence before the tribunal in 2017 and 2018 was that whether it was by an internal or an external route, there was budget available for promotions. And so the tribunal's conclusions on budget the tribunal's conclusion that the business case, which was the budget, doesn't work.
Can I just interrupt, Ms. Jolly, and I mean, this is how I understood the tribunal's reasoning. The availability of a budget is a consequence of somebody persuading the person with the purse that there is a business case for a particular post. So that seems to me to be the common sense link between a business case and a budget. A budget is a consequence of someone having made out a good business case. But there's a second issue with a budget. But budget for what?
But, my lady, just to walk that back one step,
Yeah.
if you accept that there's a budget because someone's made a business case,
Yeah.
how does one make the business case? If you look at the documents in 2018 that I took you to, the business case that was made out included aspects about whether the claimant was engaging with the research and the PhD criteria. So there in your own analysis is the links, the causal links that we see in the authorities, sufficient to engage section 15(1)(a). Is there a budget? The budget is because someone's made out a business case. How does one make out the business case? From a range of factors that the tribunal doesn't set out anywhere. And that's important for the perspective of section 15(1)(a) links, because if the business case includes the things that Dr. Garrett Brown set out in her, we're looking at 2018, in 2018, those included the claimant's ability to satisfy the research and the PhD criteria. So if you're right about that, my lady, if he couldn't properly satisfy the university that he had the research and PhD criteria, he couldn't make out a business case and there wouldn't be any budget. That is sufficient.
You're aligning case with business case, I think.
Business case to budget, business case, business need, budget. Those links, we say, the tribunal hasn't made any analysis on how that chain forms, but all it seems to do at 222.2 is itself elide budget and business need. Mm-hmm. The other point to that is actually in Dr. Hyde's decision on his grievance appeal in 2017 himself. This is at paragraph 170 of the decision. If you look at that in this context,
that's Professor Foster.
Sorry, I think that might be the wrong. I may have the wrong reference for you. Yeah, sorry, it was 161. I think the paragraph I took you to. No, I'm sorry. I'm so sorry.
Maybe it's pages rather than paragraphs.
Paragraph 61. That must be what it is. Sorry, yes, it is pages I'm looking at.
Yes, got it.
Thank you very much. Within that that I took you to, you see that Dr. Hyde, so this is 2017, Dr. Hyde's own reference on page 1. So sorry, I've dropped this reference. Yeah. Yeah, that's what I'm looking for. 169. Thank you. Yes, sorry, thank you very much. I got it. Thank you very much. It's page 169. And it's about the middle of the page, the paragraph that starts, during our meeting, we discussed the need for a head of school to create a business case for support and progression. And as such, I will not elaborate on this again here. and then it goes to, on 171, I'm so sorry, I've seemed to have, yeah, sorry, and then it goes on 171, middle paragraph, sorry, second paragraph there, which starts while you stated.
Yeah.
You see that paragraph. It says 5 lines down, other AL staff have been supported in undertaking various kinds of research activity where it's been aligned with the business needs of their school and when it's been organised through their line manager. They can also be supported in commencing work towards a PhD, again within the constraints of business needs. So there seems to be within that, interchangeably in all the decisions, business need, business case, but also within it, subsumed within it, the need for the research and PhD work to be ongoing. My lady asked about 2017, and I'll just say, but won't take you to it, that my learned junior tells me that there was no evidence in Mr. Dawkins' discussion that there was no budget. So talking about a business case there wasn't the same about the budget. Mr. Dawkins' reasons related to the strength of the application, suggesting there needed to be an overlap between the PhD and research. So that's why we say it's incredibly important that the definitions of business case, business need and budget were set out, and without it, we say the business case was bound to be not just simply budget, but other factors. And to that end, I'd like to take you, please, to paragraph 261, going back to the Tribunal's own decision on section 15, which is at 217 of the core bundle. So you recall we looked at 259 and 260, where they say it's in no sense whatsoever, but by the absence here of an available role or business case. So here they don't say the absence of an available role or budget for a role. They talk about business case. And then at 261, they do something curious. It's very difficult to understand what they mean. They say, Mr. Pike demonstrated he didn't meet the required standards of the role because of his ADHD, sleep disorder, or some combination. It may be that would have been the case, but having been open to the possibility of alternative pathways, he didn't engage with the university in identifying one, and that wasn't properly explored. With us not satisfied, the rejection of his applications were caused by something. Instead, they stemmed from the absence of a business case for a role here, not a budget, and or his failure to engage with the university in identifying a progression pathway for him. Now, we say these two paragraphs extremely curious. Having determined that the business case was the reason, or the absence of the business case was the reason for the failure of his progression applications, they seem to acknowledge within those paragraphs that his disability may at least have impacted upon his capacity or ability to meet the framework standards, and that they disadvantaged him. If they recognise that there is at least a connection between the framework and his disability, but they discount it as being causative because of his failure to engage, which looks as though that's what they're doing, that suggests that the conclusion that the failure to engage itself may have been the reason for rejection suggests three things. One, if a failure to engage is causative in any material sense, rejection then wasn't a hard question of budget. It means there was scope for some other causative reason. Two, if a failure to engage was causative, that begs the question of why he needed to engage and what he needed to engage. The second sentence of paragraph 261 suggests that it's the claimant's own fault causatively because he didn't properly engage with the university in identifying alternative pathways to meet the required standards. That suggests his inability to meet those standards was an at least part causative for Section 15.1a purposes, because he needed the alternative pathways in order to meet the essential framework requirements to start with. In other words, his failure to engage was important because had he engaged, he would have been able to meet the framework requirements. That, we say, creates a strong link and more than sufficient link for Section 15.1a purposes. Because taken at face value, those two paragraphs suggest the tribunal did accept his disability affected his ability to meet the framework. And that then takes me back to the question at Section 15.1a. Did that play any material part in the unfavourable treatment? And that is the triviality threshold, with which we were discussing some moments ago. Even if it wasn't the sole reason, we say that the muddled reasoning in 261 and 262, which we say isn't clear by any event, suggests that there was more than one causative reason. And in those causative reasons, there was a series of links. So we say that, and what they also show is that that means that the business case isn't just about budget. The business case entails a series of the sorts of things that we've been talking about. And it's not the only answer. It's either not the answer at all or it's not the only answer. Because if it were, his failure to engage with the process would have been simply irrelevant. What seems much more likely, we submit, is that the business case, yes, it was a necessary component of the framework. We've seen it's written there. But it was part of the story. And that's why I suggested some time ago that if you had a very strong application, that you were meeting the research requirements or you were on a pathway to a PhD, then a business case may well have been made, was likely to have been made on what we've seen and then to take my Lady Justice Laing's comments, a budget may have been found. And that brings me full circle to where we were at the beginning, my lord, when you were saying, isn't that the beginning and the end of the story? And we say that better explains. So I'm so sorry.
No, I think you've made this point. I wanted to go on to the next page of the tribunal judgment, or the next part of the story. If you're right, then the tribunal should have found that the claimant succeeded on Section 15.1a.
Yes.
And then, as you say, the next stage would be proportionality, straight justification.
Yes.
And the tribunal make a finding at 266, and I'd be grateful if you could address us on that, unless you were about to come to it anyway.
Well, I certainly can address you on that. That is grounds 2 and 4 of.
All right. Okay.
And it may make more sense for me to come back to it.
Well, although ground 1 is
ground
critical,
1 is,
and we've spent a lot of time on it, but we need to let you get on to 3, 2 and 4.
Thank you very much.
Should we do that then? Unless my colleagues have got any questions on ground 1.
Thank you very much.
You were going to go next to ground 3.
I was, thank you very much. And what I say about ground 3 is that the legal basis of Section 15.1a and Section 19 are different, but there are sufficient similarities for some of the points I've made to carry over, and I'll make it clear what I say is different. The establishment of, and just so that you have it also, if you would like to, my skeleton deals with ground 3 very briefly. It's paragraphs 88 onwards at page 386. The establishment of indirect discrimination requires the 4 ingredients we've looked at in section 19. And I don't propose to spend any time on those. The principles regarding group and particular disadvantage under section 19 2b and c were summarised and set out in ESOP and Home Office, which is, I think, at your tab 29 and page 379 of the authorities bundle. This was an indirect discrimination claim based on race and age, one relating to qualifications for promotion, and in the other, pay systems based on length of service. And this court is likely well familiar with Lady Hale's analysis on a particular group disadvantage, but I'll just take you to some key points, paragraphs 25 to 29, and I'd invite you to read those subsequently. But I'll just take you to some of the key points here. So paragraph 25, to give you some context for this, paragraph 23, Lady Hale sets out that she's going to go through the certain salient features of indirect discrimination claims. And paragraph 25 deals with the contrast between direct and indirect discrimination. And 4 lines down, she says, indirect discrimination requires a causal link between the PCP and the particular disadvantage suffered by the group and the individual. The reason for this is that the prohibition of direct discrimination aims to achieve equality of treatment. Indirect discrimination assumes equality of treatment, etc., but aims to achieve a level playing field where people sharing a protected characteristic are not subjected to requirements which many of them cannot meet, which cannot be shown to be justified. And then 26, a third salient feature is that the reasons why one group may find it harder to comply with the PCP than the others are many and various, but over the page, at A, these various examples show that the reason for the disadvantage need not be unlawful in itself or be under the control of the employer or provider, sometimes it will be. They also show that both the PCP and the reason for the disadvantage are but for causes of the disadvantage. Removing one or the other would solve the problem. At 27, a fourth salient feature is that there is no requirement that the PCP in question put every member of the group sharing particular protected characteristic at a disadvantage. And then at 29, a final salient feature is that it's always open to the respondent to show that his PCP is justified. In other words, there's a good reason for it. And then at 31B over the page, four lines down, the respondent argued, how, it is said, can one know what that disadvantage is unless one knows the reason for it? And the court may recall that essentially this argument before the court was about whether you needed to be able to establish the reason causatively for the disadvantage, and the court held that you didn't. What Baroness Hale here said is what is required by the language is correspondence between the disadvantage suffered by the group and the disadvantage suffered by the individual. And then she goes on at paragraph 32 to deal with the question of undeserving claimants. And 6 lines down, sentence that starts, but in any event, in the middle of the paragraph, it must be open to the respondent to show that the particular claimant was not put at a disadvantage by the requirement. There was no causal link between the PCP and the disadvantage, because he didn't prepare or didn't show up at the right time or in the right place to take the test or finish the task. A second answer is the candidate who fails for reasons such as that is not in the same position as a candidate who diligently prepares for the test, turns up in the right place and finishes the tasks he was set. In such a situation, there'd be a material difference. And then a third answer is that the test may in any event be justified despite its disparate impact. Now, that analysis in ESOP is reflected in an indirect age discrimination case of Ryan, which is at tab 36, page 536.
What do we get from this that is critical in the present case?
I'm so sorry, my lord.
What do we get from this that is critical in the present case?
What we get from it is a question of what the particular, about the question about advantage. And what we get from it effectively is whether or not the tribunal had properly understood group and particular disadvantage. In short, if they couldn't understand group and particular disadvantage, they weren't properly looking at causation for these purposes. So they had to understand what they were looking at. So the case of Ryan and South West Ambulance Service, it was an EAT case before Mr. Justice Tucker. If I just run through the facts very briefly, because you may not be familiar with them, the claimant was an education business manager who claimed that she'd been indirectly discriminated against because of her age. The respondent had operated a talent pool for recruitment, access to which was required by a grading system or the appeal of any lower outcomes or self-nomination. The claimant hadn't been able to access that talent pool because she had not met the grades required, but nor had she sought to appeal or self-nominate. She later sought to express interest in 2 posts that were only open to those in the talent pool. And because she was not able to, because she was outside the talent pool, she claimed Section 19, indirect discrimination on grounds of age. She asserted a PCP of promoting managerial staff on the basis of pre-existing membership in the pool discriminated against those aged 55 to 70. And the tribunal found that those in that age group did have a reduced likelihood of being in the talent pool, and therefore group disadvantage was established, but no individual disadvantage was established because the cause of her exclusion from the talent pool was her failure to appeal or to self-nominate. And the relevant paragraph that I'd like to take the court to today is at paragraph, page 554. And at paragraph 53, that sets out what the tribunal had found. And then I invite you to look at paragraph 55. I'll invite you after today to look at 55 to 58. But what I specifically wanted to, forgive me, take you to, so I won't take you to it now for time, but I'd invite you to look at 55 to 58. But then I'd like to take you to paragraph 63, which is at 557. And I say that the facts of
tell us what this case teaches us.
I'm so sorry.
Just tell us what this case teaches us. And
well, we say that the way that the ESOP principles were applied to the facts in that case was instructive. And really what it tells us is that because the case proceeded on the basis that the group disadvantage was the reduced likelihood of those in the affected age group being in that talent pool, all those in the group suffer individual advantage. That's really the headline point. And that but in that case, the respondent sought to argue that she was the undeserving claimant point, the undeserving applicant point. And Mr. Justice Tucker said, well, in order to have successfully advanced the undeserving claimant argument, the respondent would have had to adduce and prove this was because of her performance, or indeed other reason, but certainly that it wasn't because of the group disadvantage. So the essential point, and I'll invite you to look at 55 to 58 and 63 to 70 subsequently, but the essential point is that where the group disadvantage was reduced likelihood of being able to apply or proceed, everybody in the group suffered that individual disadvantage, and so must the claimant. And we say that that is instructive for our purposes on ground 3 and particular disadvantage. The tribunal's already looked at the judgment paragraphs which are relevant, but I will just take you. So the central reasoning of the tribunal's position on substantial disadvantage was what we looked at 220 to 222, so we've already looked at that. But in respect of the Section 19 claim on disability, the tribunal reaches its conclusions at paragraph 279, which is at page 221 of the core bundle. And what the tribunal concludes at page 279 is that there was no particular disadvantage to the applicant based on its reasoning on substantial disadvantage for section 20. That's what it says at 279. And you'll recall the reasoning on section 20 disadvantage was about the business case. And so I make 4 overarching submissions on ground 3 and particular disadvantage. The first is the tribunal could not properly consider disadvantage, whether group or particular, if it hadn't properly understood the PCP which was said to cause that disadvantage. I'll explain that, my lord. I can see you look puzzled, but I'll explain it. 2, the tribunal failed to properly consider the structured approach necessary when determining questions of both group and individual disadvantage, which led it astray. 3, the tribunal's analysis failed to reflect that particular disadvantage involved the reduced likelihood or opportunity of promotion in accordance with the framework. And 4, there was no sustainable basis on which to conclude that the respondent was not put to the relevant disadvantage. In other words, there was no basis for the tribunal to find to conclude that the claimant had not been put to the relevant disadvantage. So sorry. Taking each of those in turn. 1, the tribunal set out its conclusions on the application of the PCP at paragraphs 212 to 218 of its judgment, which is at pages 207 to 208. And I'm going to, I'll short circuit this by inviting you to note that Mrs. Justice Easy, below at paragraphs 119 to 121 of her judgment, accepted that the tribunal had got their approach on the application of the PCP wrong.
Sorry, give me the paragraph numbers again.
119
Yes.
to 121.
Yes.
And the summary version of that is that the tribunal had become caught up with the question of whether the framework actually required the attainment of a PhD and what sort of a PhD. Because the tribunal had concluded at paragraph 217 of its judgment that an applicant only had to be on a pathway to a PhD and there were alternatives to progression, exceptionally by demonstrating equivalence, the tribunal concluded that the PCP was not applied. In other words, the tribunal concluded that because there was some flexibility within the scheme of the requirements, no PCP was applied at all. And as Mrs. Justice Eadie correctly recognised, that was the wrong approach. The respondent in its version says, well, the tribunal got the basics right. And we say, this illustrates on section 19, it really didn't, because the foundations of its section 19 analysis were unstable. Before it came to the question of disadvantage, whether group or individual, it had to have been correct on the PCP. It had to know whether the PCP, what the PCP was and ensure that it was applied before it could assess whether that PCP led to group or individual disadvantage. And it didn't, so it went wrong there. Secondly, we say that both Aesop and Ryan demonstrate that the complex issue of disadvantage requires a careful and structured approach. And what the tribunal should have done was consider first group disadvantage under section 19.2b and then move to consider whether the claimant was put to that disadvantage under section 19.2c. It was important for the tribunal to properly consider group disadvantage in order to analyse the existence of individual disadvantage. Without recognising that there was any group disadvantage to begin with, namely that people sharing the claimant's protected characteristic had a reduced likelihood or a reduced opportunity of achieving promotion under the framework, the tribunal couldn't properly assess whether the claimant was put to the corresponding disadvantage. And we say when you look at the tribunal's analysis on disadvantage, and that appears at paragraphs 219 to 225 of its judgment, there is no reflection of the kind of analysis one would expect to see post-Aesop on Ryan, but it simply refers back to its conclusion on substantial disadvantage at paragraph 220, rather than conduct any analysis of either the group or the individual disadvantage that the PCP caused. Instead, it became distracted by the claimant's own conduct and doesn't appear to direct itself in accordance with whether the PCP does or would put disabled people with sharing the claimant's characteristics at a disadvantage. So instead, it was concerning itself with the business case rather than concerning itself with the application of the PCP, which we say on its face clearly, and even by the concessions which were given by the respondent, must have shown that there was both a group and an individual disadvantage of that PCP. Then third, the alleged disadvantage in respect of disability was set out in the list of issues appended to the ET judgment. And I won't turn you to it, but for your reference, it's list of issues, paragraph 16b. It's at page 230 of the core bundle. And the claimant specifically there relied upon the increased difficulty, or put another way, the reduced opportunity that people with ADHD and or sleep disorders have in achieving promotion to grade 7. So it was set out there. In relation to age, the tribunal outlined the claimant's position on group disadvantage at paragraph 287 of its decision, page 222 of the bundle. In sum, that persons aged 55 to 59 would have increased difficulty or reduced opportunity than younger age groups. We say that in terms of the reduced likelihood, group disadvantage in respect of both characteristics plainly must have been established. The tribunal then had to ask whether there was correspondence between the disadvantage suffered by the group and that suffered by the claimant with that disadvantage. And we say, given that the group disadvantage was based on reduced likelihood or opportunity, and the claimant was part of the relevant group, prima facie, applying the analysis in Elisabeth and Ryan, he did suffer that disadvantage. He was a grade 6 lecturer who had ADHD and was between 55 and 59 years old. He was in the groups affected by the disadvantage. As that disadvantage was a reduced likelihood of promotion, he will have suffered it pursuant to paragraph 56(1) in Ryan and paragraph 31 in Aesop. And we also just invite you to note Mrs. Justice Eadie's comments at 132, where she says that effectively somebody with the specific disadvantages that the claimant's disability caused with this framework, in ordinary circumstances, one would have expected to see a group disadvantage established. I'm paraphrasing, but I think that's fair. She does, however, just so that I'm clear about what I'm saying, she in fact went on to say that there was no group disadvantage because of the findings of the business case. So although she said that ordinarily she would have found that in these circumstances there would be group disadvantage, she went on to say, because of the tribunal's findings of the business case, she ultimately accepted no group disadvantage. We say, based on the legal analysis that I've just made, that conclusion wasn't viable. The question was, did the PCP, which required some shape or form of a PhD or equivalent, or being on a pathway, put or would put disabled individuals with ADHD or sleeping disorder at a disadvantage? The answer to that must be yes, for the reasons that Mrs. Justice Eadie recognised at paragraph 132. The next question, the tribunal not having asked either of these, was whether the claimant was also put to that corresponding disadvantage, and we say the answer to that must also be yes.
But that's what, at the moment, glancing at the respondent's skeleton argument, seems to me that Mr. Williams is hanging his hat on the business case point. If you're right that the tribunal finding about no business case was wrong, then you don't need this point. But if you fail on the business case point, this ground doesn't make your case any better. It's both or neither, isn't it?
Well, the reason why I've just taken some time to explain this, because they don't necessarily stand or fall together. They probably do. But what you see on section 19 is the tribunal they've gone wrong on the PCP. That structured analysis, they've gone wrong completely on the PCP. Yeah. Having gone wrong on that, they haven't actually considered group disadvantage at all. So whatever my learned friend says about the business case, it was still incumbent on the tribunal to analyse the group disadvantage of the PCP. Mm-hmm. We say that because the PCP involved the recognition of because the PCP that was applied involved both PhD and research criteria, plainly they put the group at a disadvantage, we say. Plainly, for the reason we set out, the individual was then put at a disadvantage. The question then, on section 19, is does the business case help on proportionality? We say that they don't, that the failure for the tribunal to conduct any of that analysis means that no matter what you might find about the business case in respect of section 15.1, my ground 3 can still stand, because there's literally no analysis at all on any of this, and they've gone wrong from the starting block.
But even assuming that's wrong, that they approached this in the wrong way, isn't there a further question, which is whether any such error is material on the particular fact?
Well, what I would say, my lady, to that is that the authorities are extremely clear that you have to go through each of those stages on indirect discrimination. So if they haven't gone through any of those stages properly, they've clearly